Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State v. Wilson, case number 24 AP 241. Representing the appellant, Kwesi Wilson, is Albert Fox. Representing the appellee, the state of Vermont, is Robert Plunkett.
Thanks very much, and good afternoon, counsel. We'll hear from counsel for the appellant. First, of course, please identify yourself and your client and then proceed.
Yes, this is attorney Albert Fox on behalf of Kwesi Wilson, and I'm here obviously on the bail appeal. The first, I think I should address the motion filed by the state to dismiss. I don't know if the court has seen that.
Yes, we have that, attorney Fox.
Okay, so I do understand the time and issue. I filed this appeal after an entry order from the trial court that said in essence that this what the jurisdiction for this review would be an appeal. I filed originally in trial court arguing that there was a change of circumstances, and the response from the trial court led me to believe this was the proper jurisdiction. I realized.
Mr. Fox, can you hear me?
Yes, I can.
You're fading in and out. I wonder if it would help if you turned off your camera.
Yes, sir. Is that there?
Yeah, let's try it that way. Keep going, please.
Thank you. To address the merits of the appeal, I believe the brief speaks for itself to a great degree, but the court obviously reviews factual issues with the standard of plain error. I do believe plain error exists in this case. The 3 exhibits the state submitted are 3 law enforcement exhibits from Officer Osgood, Deputy Thomas, and Officer Doucette. At the way of evidence hearing, the state relied on counts 1 and 3, the 2 felony eludings enhanced to a habitual life offense for the purposes of hold without bail. They clearly, and I quoted from the transcript here, did not proceed on count 2 because of a lack of a sworn statement regarding the vehicle owner regarding the lack of permission. So the 2 counts that are held are counts 1 and count 3, felony eluding.
Mr. Fox, wasn't there a stipulation here as to the weight of the evidence being great on counts 1 and 3?
Yes, Your Honor. So there was a stipulation. I think that the trial counsel at that point, this was prior to my engagement, did stipulate that the weight of evidence was great at that hearing. I think that nonetheless, the burden is on the state and for the trial court to find that the weight of evidence is great, requires the court to make findings that essentially the affidavit contains enough sworn evidence to meet that 12D standard, and simply put, it does not.
And what then would be the purpose or benefit of a stipulation if the court needs to go through the evidence and make findings on the issues in any event?
I believe that the benefit of a stipulation is to say that the trial counsel is not arguing this point, that they're not going to contest it or to basically go after testimony or anything of that nature, that they're focusing on prong two. But the fact that the state admits the affidavits even when there's a stipulation indicates that there needs to be a factual basis in evidence and in the court.
But those exhibits were pre-filed, weren't they? And then the stipulation was made several days later at the hearing.
That's true. The exhibits were filed, but they were admitted and relied upon. In the transcript of the findings, you will see that the trial court does repeatedly refers to the evidence in the affidavits and draws from them. So clearly, those were relied upon and considered and in evidence. In essence, there's no demarcation line between the two prongs. We did not only talk about prong two. We had the stipulation, but we also had the affidavits admitted into evidence and the conclusion that evidence was great. It wasn't contested, but the court did conclude that the weight of evidence on prong one was great, and it concluded that on the basis of the affidavits, not just a stipulation. So I think it's a very important question is, what do those three affidavits show? And the three affidavits show that essentially two officers observed the sedan operating at different times. They both engaged in pursuits of it. Neither of them identified the driver. Officer Osgood identified that the operators were black men, but that was the extent of his observation. Officer Doucette did not identify that. The affidavit contains Deputy Thomas's affidavit sort of contains a reference that leads people to believe that Mr. Wilson was found behind the wheel of the red sedan, but he never was. The summary of basically the account of Mr. Miller was that he called a friend, found out that it was Mr. Wilson had borrowed.
Mr. Fox, can you hear me?
Yes.
Sir, can you hear me?
Yes, I can.
Yeah, you know, you're fading in and out. I wonder if you should call in on the telephone to complete your argument. Have you got the telephone number? I'd suggest that you do that. I think we're all having a hard time hearing you.
Okay. Can I try one thing first and see if that helps?
Yes, I can
Is
hear
it
you all right,
okay
Mr. Fox.
All right. Well,
He asked if he could try one more thing before calling in to see.
oh yeah,
Help.
please go ahead. Okay, thank you. Thanks.
I'm sorry, if it ain't clear now. If not, I'll call in.
No.
I can hear you, Mr. Fox, but I'm not sure the chief can.
I can hear you as well, Mr. Fox.
All right, I'll turn off my camera.
Mr. Fox, the chief is going to turn off his camera to see if it helps his ability to hear you.
Yes, I heard that. Thank you.
Okay, please keep going.
Okay, thank you. Let me know if it fades out. I'll try to keep my voice up. Mr. Miller basically had no information about who was operating the vehicle in the period of the eluding. There's no sworn testimony to that fact. The only indications that Mr. Wilson was in fact operating it came from Mr. Officer Doucette's affidavit and belonged to individuals who were in the car who were not identified and were not sworn to any statement. So at this point, I would be making the argument that there is not sworn admissible evidence to the element of operation during the period of eluding, and therefore the evidence of guilt is not great, and the first prong that has Mr. Wilson held without is not being met. Thank you.
Okay. Thank you very much. We'll hear from counsel for the appellee. Please identify yourself and your client and then proceed.
Thank you. Good afternoon, Mr. Chief Justice, and may it please the court. I'm Rob Plunkett. I represent the state of Vermont, the appellee in this matter. And what I'll do is I'll jump right to the merits. I did file the motion to dismiss on whether or not we should be here at all. And also, Chief Justice, if you cannot hear me, let me know, and I can try to turn off my video. So as to the merits of actually appealing the hold without bail, here, as Justice Eaton had noticed, there was a stipulation to the evidence of guilt being great at the trial court below. And that is the only issue that is on appeal here. And I should explain a little bit about how our weight of the evidence hearings go. I think Your Honors probably know this already, but it is two prongs. There is the initial prong, where essentially is a 12D hearing, and then it switches to discretionary release. And here, when we have a stipulation, the first prong happens very quickly. And if you read the transcript, I believe this is correct, the trial court here found that the evidence of guilt was great based on the stipulation. And Your Honors review this for abuse of discretion, but also review the record and make your own determination. And Your Honors can make the same determination as the trial court had done, that based on the stipulation, the evidence of guilt was great. And there were pre-filed exhibits, which usually happens. That's not necessarily the extent of the exhibits that would be submitted at a hearing. And if there's a stipulation, there probably would not be any more exhibits filed or any testimony taken for the first prong. Presumably that's what's happened here. Frankly, I don't remember if I had anyone ready or if I was going to play one of the videos. But the exhibits all go to discretionary release. The underlying fact, as well as the other exhibits that have been filed, which I believe were the prior criminal record. So here, Your Honors, even if you can review the initial hold so long after it was done, you can do the same thing that the trial court did. And even if you go further into the affidavits, the only element that is challenged is identity of Mr. Wilson as the driver. And that is actually clearly spelled out in the exhibits. In Exhibit 3, this is page 55 of the appellate volume. Mr. Wilson admits to driving that car. He indicates that it's around 12 o'clock, around noon. And in Exhibit 1, this is page 49 of the appeal volume. I believe it's Deputy Thomas. So anyway, that law enforcement officer initially saw the car at 1:22 p.m. Taking that evidence in the light most favorable to the state shows that Mr. Wilson was the one driving the car. Even further from that, regarding the discretionary release, the other argument here is that the court should have considered the weight of the evidence in determining discretionary release. And here, again, based on the stipulation, the court did not need to, but regardless, the court does not need to review all of the 7554 factors when making a discretionary release determination. Thank you all, and that is the end of my argument.
Okay, thank you, Mr. Plunkett. Mr. Fox, can you hear me still?
Yes, I can.
Do you have anything more?
Yeah, I would just briefly say that my reading of the transcript was that it was pretty, and Your Honor's reading obviously dictates this, but I think there needs to be in the record a basis to find that the weight of the evidence is great. There was a stipulation. Reading this transcript, I don't see any evidence that there ever was something more to be drawn. The affidavits are pretty clear that there are not sworn statements from the people in the car who weren't even identified. I don't know what other video.
Okay, please wrap up your argument.
Okay, thank you. I can conclude.
All right. Thank you. Call the conclusion.